taking the time out this morning to join us. Again, my name is Peter Matos. I'm with Malloy Malloy. I'm one of the patent attorneys. Some have said very boring individuals are patent attorneys, so I'll try not to be that way. But today I just wanted to give you a few pointers in the world of patents and how to protect your ideas, your innovations, your inventions. And just briefly, patents and protection for innovations can come in many different formats, many different shapes and sizes. It can stretch from an ordinary object or machine that you might develop to sometimes a way of doing business, to a method of producing a particular product, to a design of a particular product, the design of the shape of a pen, the shape of a cup, the shape of a platter. There is a variety of different things that can be protected by way of patent, and one of the things that really is at the starting point is don't underestimate what you can or cannot protect. Give it some thought. Oftentimes when you solve problems in your own business and come up with something, a tool, a way of doing something that solves a problem, you're going to arrive at something that can be protected. And it's worth at least a talk or a discussion with a patent attorney to see, is this something that I can protect? In these little cards that we prepared, we outline a few specific points, just some basic tips that you want to keep in mind at the infancy of protecting your invention. When you come up with something, things to bear in mind so that you don't take some missteps that could conceivably cause you problems down the line. The first point that most people probably recognize off the bat is the secrecy of a patent. You definitely want to do your best that whenever you've got an invention and innovation, you don't want to release it to the public. You don't want to start telling a lot of people about the invention. You want to try to maintain the confidentiality until you're ready to release it, until you're ready to be the one that controls when the product goes out, when people start to find out about it, because that can have a variety of different impacts on you beyond just somebody else knowing and running with it in advance of you, but it can also have negative impacts in terms of what you can protect. Your ability to protect your own invention can be jeopardized by somebody else talking about it, blabbing about it, showing it, or making an example of it, even if they're doing it in an unscrupulous fashion. So confidentiality is very important. With regard to your attorneys that you speak with, we're bound by confidentiality. Just even having a casual conversation, we can't discuss the inventions. Anybody else you talk to, realistically, they should have some sort of a confidentiality agreement, some sort of a written document that says, we promise to keep this secret. So that's something very important to keep in mind. Timing is also a very important and significant thing that I want to talk about relative to inventions. The United States has an interesting system that's different from the rest of the world. The United States says you can have a product out there for up to a year and then still apply for the patent. What happens though, if you adhere to that leniency that the United States allows you, if it turns out that this product, this innovation, this method, this computer program really takes off and really does well and perhaps has benefits outside of the United States, you will be foreclosed from being able to protect it outside of the United States. So the rule of thumb is, if at all possible, you want to take steps to protect your invention, or at least see what's available to be protected before you put it out there in any form, before you put it out there at a trade show, realistically even before you dramatically test the waters in terms of what a consumer may or may not buy. At least find out what sort of steps might be available to protect your invention, because again, not doing that can significantly jeopardize the rights that ultimately you'll have and you'll be able to get. So those are things that are very important to keep in mind. Another issue that often faces us is I'll sit down with inventors and they'll tell me, oh, but this is just at the beginning stages. I'm not ready to protect this invention. I'm not ready to get a patent for this. I haven't figured it out yet. I have to talk to an engineer, or I have to talk to a designer, or something to that effect. More often than not, that's not the case. More often than not, that inventor has more than enough to protect their invention right there. Because preparing a product that's commercially viable, that's going to go out in the marketplace, it's not going to break easily, that maybe you don't even necessarily want to take the product to market yourself, but it's just something that you think someone might want to take to market. Getting it to that final form is one thing, but it really is separate from the protection aspect of it. In order to protect it, you basically have to have your invention in enough detail so that you can explain to someone who is in the business of making something like this is how you do it. and that's sufficient. So to give you the extremes, if you've come up with a small device that lights up and spins around, those are fairly basic mechanical principles. Any designer, any factory or fabricator could put that together. It's enough for you to say it needs to have 3 lights, it needs to have these types of wheels, these types of gears, simple things. You don't have to get into the particulars of it. The other extreme, if your invention is, boy, I love that flying car, well, now you need that principle of how that's going to happen. So don't sell yourself short in terms of where you are with your invention, because oftentimes you're further along than you think you might be in terms of protecting it. And protecting it really opens the door to your ability to collaborate and your ability to take steps beyond that, because a significant issue that you have to be very cautious about is that collaboration often means co-invention. So if you start talking to an engineer, you start talking to a designer, you start talking to a group of people and brainstorming, that's a great way to evolve an invention for sure. But now everybody who's contributed an inventive aspect or an idea to that overall concept now all of a sudden has become a co-inventor. It doesn't matter how big or small their contribution is. Even the smallest contribution, if it's ultimately included in what you're protecting, now they're an inventor. So if you develop a software program that does some innovative things, and you've got the programmers giving you ideas, what about this? Or you've got other people collaborating. Now those people are co-inventors. And what that means is if you don't have something in writing with them that says that you own what they did, they are now equal owners on the same footing as you are. So this great idea that you come up with 95% of, that 5% contribution that designer, that fabricator, that programmer came up with, has given him 100% ownership in the invention. So you've got to be very cautious in terms of that. So that's another good reason why taking steps to see what can be secured before you start collaborating is a very good thing, because that will help you draw a line in the sand between what your invention is and what their contributions are. How could they help you contribute if you've already taken these steps to protect it before they even came to the picture? So those are just that's an important pitfall you want to bear in mind. And again, don't underestimate where you might be with an invention, because you're often further along than you suspect. Action.